All right. Board of Appeal and for the sixth district of the Florida now that the Honorable Joshua A. Mize, judge presiding, all persons having business before the court draw near to the attention and will be heard. And God save the United States of America, the state of Florida, and this honorable court. Please remain standing for the pledge.
Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you, folks. Please be seated. Okay, welcome to this session of the Sixth District Court of Appeal. My name is, as the marshal said, Judge Joshua Mize. Sitting to my right is Judge Jared Smith. Sitting to my left is Senior Judge Richard Orfinger. We have three cases on the docket today. First case is 23-1252 Todd Allen Lohr versus the state of Florida. The appellant, please approach. Okay, counsel, how much time would you like for rebuttal?
I would like to reserve 5 minutes.
Okay. Please proceed.
Good morning. May it please the court, counsel. I'm Paula Kaufman, and I appear this morning on behalf of the appellant Todd Lohr. We are here requesting a new trial following the denial of post-conviction relief with a hearing. Quite simply, too many things went wrong in the first trial. And we believe there is a very reasonable probability that the outcome would be more favorable to Mr. Lohr in a retrial. As to the issues we are arguing today, there are very few disputed facts. The acts or omissions that we're complaining about are apparent from the four corners of the face of the trial transcript. It's right there in black and white. Where the parties disagree concerns our contention that there are numerous instances of judicial error here involving decisions by the post-conviction court on matters of law and the legal conclusions reached by the post-conviction judge to the effect that any deficient performance did not prejudice Mr. Lohr. I want to begin by addressing two interrelated claims, basically involving the same pretrial ruling. That would be the trial judge's ruling rendering inadmissible any Williams rule evidence. Claim 2 involves trial counsel's opening the door to evidence that had previously been ruled inadmissible in Mr. Lohr's case. That ruling was, the court ruled that evidence of criminal wrongdoing on the part of my client, including any evidence of criminal intent, would be limited to evidence regarding the 3 charges that Mr. Lohr went to trial on. The court even went so far as to prohibit the admission of evidence to the effect that Mr. Lohr may have been positioning himself, standing behind other uncharged victims, because the state had chosen not to charge more than 4 counts, and because the state had elected not to seek the admissibility of any prior bad acts, Williams rule evidence, presumably negating a defensive accident. So what happened at trial? During cross-examination by defense counsel, one of the charged victims, BR, was asked whether anyone else in the youth group had ever indicated to her that they were also a victim, that they had also been touched or grabbed. That question was propounded by Mr. Lohr's lawyer. The witness responded that a 4th victim, an uncharged victim, had also made a claim similar to the claims that were being made by the charged victims in this case. Defense counsel then attempted to impeach that witness with a prior inconsistent statement. Basically, this amounted to bringing the victim count in this case to 4 from 3.
But counsel, it was your client's lawyer who did that.
Yes, sir. And we're here on a claim of ineffective assistance of counsel for opening that door. It is our contention.
So your client my understanding is your client basically couldn't testify to much, right? He said, I blacked out, I don't remember anything. So his lawyer is left with, okay, I'm gonna have these victims testifying and the other, witnesses testifying. And I'm gonna have no way to rebut it. I'm gonna have unrebutted testimony from multiple people saying, my client committed these acts. And the only thing my client's gonna be able to say is, I was so blacked out drunk, I couldn't remember anything. Could a lawyer not look at that and say, listen, I've got to throw a Hail Mary here, right? I've got, because a high risk decision is not necessarily a bad one if you're facing very long odds, right? I mean, that's why at the end of the football game, they throw the long ball. They're probably not going to win, but if somebody doesn't catch that long pass, they're definitely lose, right? Because they're behind. So when he's looking at multiple unrebutted witnesses, his client unable to say anything and admitting he doesn't remember, right? Could a lawyer not look at that and say, all right, this might turn out bad, but maybe there's a 80% chance this turns out bad, but if I don't do it, there's 100% chance, right? A high risk decision is not necessarily an unstrategic one.
Well, first of all, there are other things that defense counsel could have done, and I hope time will permit.
I know, but you
me to
argued
get to
this
those
one,
issues.
right? This is the one you opened with,
Yes,
that this was ineffective. And I'm just saying, I didn't practice criminal law, but if I'm looking at a slate of witnesses saying my client did this, and there's no one to rebut the testimony, and all my client can say is, I can't rebut it because I was so blackout drunk, I don't remember anything. You know what I'm thinking? If I don't find a way to trip up these witnesses, my guy's going to prison.
and there was testimony at the evidentiary hearing below that there was actually at least a two-pronged approach here. The defense was
One of the prongs was
going to be, yes, sir.
I guess what I'm
accident.
saying is, in order for a decision to be ineffective assistance of counsel, it not only not had to work out badly, and maybe it didn't even have it's not even enough that it had a high likelihood of working out badly, right? Because the alternative had even worse likelihood. You have to show us that a reasonable attorney wouldn't have done this. And I'm just saying, if I was looking at that slate of facts and I've got all these witnesses saying my client did this and no way to rebut it, I'm thinking, I better throw the long ball or my guy's going to prison. And you have to make the case to me that that was unreasonable, not just that it didn't work out well.
That is what we are saying.
So why was it unreasonable given that situation?
Well, counsel was faced with two choices here, and he decided that he had more to gain by pointing out an impeachable inconsistency. But what was that inconsistency? Who said what to whom? That's it.
But without any inconsistency, the unrebutted testimony was he committed the crime from multiple witnesses. Like, what was his alternative?
They were working on an argument that the victims were not credible, that they had embellished, that they had a chance to get together on the bus ride back home to get
How do
their
you show
story
they're
straight.
not credible without showing some inconsistency? Those seem like the same thing to me. Like if whatever you said about witnesses, if you had 3, 4, or 5 unrebutted witnesses saying, I saw this, he did it, right? It's clear as day.
Because,
Unless you show somebody's lying, and your guy was going to prison.
Your Honor, the linchpin here is what was my client's intent. I don't believe there was any possibility that the defense could rebut the contention that these young ladies had been touched. The idea was that because of the volatile nature of the wave action, it was accidental, which makes piling on additional victims absolutely damning in this case, because
So
it might happen once, it might happen twice. Where do you draw the line?
hold on, it didn't happen twice. It happened 3 times, right? You're asked a 4th witness. So you're saying that the defense counsel should have looked at this and said, you know what, with these 3 witnesses all saying the same thing, I got a pretty good chance without showing any inconsistency of nonetheless showing he didn't do it on purpose. So I should not try to show an inconsistency, because even without an inconsistency, they're likely to believe this was an accident.
This,
And you have to show me not just that he could have made a different decision, but the decision he made was unreasonable, that it was, it was crazy for him to think, hey, with all these witnesses, they're going to think my guy did this on purpose. If I don't show one, at least, if I don't show them these witnesses are lying, my guy's going to prison. You're telling me he was unreasonable to think that a reasonable lawyer couldn't have come to that conclusion?
that is our contention. This was an unforced error It gave the prosecutor the opportunity in closing argument, right before concluding the initial closing argument, that this evidence had been brought courtesy of the defense attorney, not the state. And the prosecutor even invited the jury to consider whether it was the appellant whose hands had deliberately grabbed this fourth uncharged victim's breast.
Counsel, let me ask you, let's skip to the second prong of Strickland and talk about how it impacted the proceedings. I mean, I'm not concluding that it was deficient performance, but let's focus on the second one. The trial judge made a finding that A, it wasn't deficient, but B, even if it was, it didn't have any impact on the outcome of the case. What is that a finding? That second finding, is that a finding of fact? Excuse me, or a conclusion of law? And more importantly, what's our standard or review on that finding, whatever it is, that it didn't have any impact on the case?
I believe that's a legal conclusion that could be reviewed de novo by this court. I have to have a chance to talk about the related point 3 because it's based on that same pretrial ruling, and it's honestly even worse than what we're talking about now. So again, I believe the lawyers knew what wasn't supposed to be talked about, but it's pretty clear that 2 of the state's witnesses didn't. On cross-examination, BR, again, a charged victim, blurts out that she watched Mr. Lauer and he was getting behind other girls that hadn't come forward to say they had been molested. There was a determination by the court that the defense attorney had not opened the door on this one. The judge was very generous, I think, to this particular witness, that she just didn't understand the nuances of the court's ruling. However, defense counsel did make a motion for mistrial in the case, which was denied. The court also declined to give a curative instruction at that point. The prosecutor gets up on redirect and BR does it again, the exact same thing. He was standing right behind the girls. The court did give a curative instruction this time, but there was no motion for mistrial. Now, our contention is that if a lawyer has a good faith basis for believing that the court might grant a motion for mistrial, they may. If there were grounds for it one time, when the same error occurs 5 minutes later, you make the motion again. I don't believe that it would have been reasonable for the defense attorney to say, well, I might as well not bother. The judge isn't going to grant it. But wait, there's more. Now, this teenage girl may not have been deliberately violating the court's pretrial ruling, but then we have Pastor Tom, the loose cannon, grown man in position of authority with the church, who also violated that pretrial ruling. And I'm not even sure from reading the trial transcript how many victims he was testifying about. It's quite confusing. But he was definitely testifying about at least 4, a 4th victim, perhaps a 5th victim. Unreasonable not to move for a mistrial here.
Would the mistrial have been granted?
I think so. Absolutely. I would like to move now to points 4 and 5. They are based on the same record evidence. We argued the basic factual scenario that a law enforcement officer who went out and talked to Mr. Lauer's estranged wife and determined that she had no knowledge whatsoever that would be admissible in the case. She knew nothing except that she had learned of Mr. Lauer's predicament before the detective got to her. We have argued 2 interrelated claims here that the detective should not have been permitted to describe the estranged wife's demeanor. Completely irrelevant to the case. Should have been inadmissible. Highly prejudicial opinion evidence. Obviously, all relevant evidence is admissible. Observations concerning a person's demeanor may very well be relevant. It certainly is when it's the suspect. He's sweating, he's looking down. His state of mind, usually relevant. The ex-wife's state of mind was not relevant in this case. The fact that she was unfazed upon hearing that the guy that she was no longer living with, who, according to the evidence that we presented at the hearing below, was interfering with the father's custody arrangements. That never should have happened. So upon hearing that, and by the way, there was an objection as to hearsay, which the court sustained, but the prosecutor was hell bent.
Was it hearsay?
Well,
Counsel,
what,
was it here?
what
I
the-
asked you, Counsel, I asked you a question. I want to
Sir,
answer.
well-
Don't answer something else. Was it hearsay?
there was a hearsay objection to,
Counsel, I asked you a question. I'll answer the question I'm asking, not a different question.
oh,
Was the testimony hearsay?
I understand what you're asking me. The testimony that came in was not.
Okay.
The
Did he
testimony-
make any objection other than hearsay?
He made an objection to the detectives.
Yeah. Were there any grounds cited for that objection other than hearsay?
No, sir.
Okay,
But-
so did he make the objection that actually would have excluded the testimony?
No. The detective was about to say what the ex-wife said, which would have been hearsay. So that objection was made. That's what I meant.
Yeah,
by
and that testimony didn't come in.
True, but
Counsel, you're into your rebuttal time.
thank you.
State.
Good morning, Your Honors. May it please the court, my name is Stephen Putnam. I represent the state of Florida today. And concerning this case, the state contends that the trial court properly ruled that appellate's trial counsel was not deficient, that they used common standards for tactics and strategy when they were defending their client. Furthermore, appellant has failed to demonstrate that even if there was some merit to any of the claims, that there was a reasonable probability that he was deprived of fair trial.
Is that latter part a conclusion of law or a conclusion of fact?
That would be, it's a mixed bag usually, so I believe that it would concern both fact.
And so what's our standard of review on the finding that it did not have whatever deficiencies there were, if any, didn't
Well-
affect the proceeding?
So whenever examining these sort of cases, as Your Honor is well known or knows well, is that attorneys look in hindsight, and there are always some mistakes, no matter what trial you've done or have had, there's always going to be an error of some kind, but the court has said that this hindsight vision is not a reasonable standard. So you have to look at the attorney in his place and time whenever he is handling the case, for instance, or examining a witness. Is that what you asked? I'm sorry, Your Honor.
No, I mean, I think the trial judge did that.
Yes,
And ultimately concluded that if there was an error, and the trial judge concluded there wasn't, but sort of then went on to say, but even if there was, it didn't have an impact on the fairness of the proceeding. And my
Correct.
question is, as to that second point, and I realize we don't even get to the second point if we don't resolve the first point in appellant's favor. But as to the second point, the conclusion that even if there was error, it didn't have an impact on the fairness. Is that a conclusion of fact or law or a mixed one? And if so, what's our standard of review?
so the first part is that, or I'm sorry, the last part is there was plenty of testimony and facts that provided at trial from multiple witnesses that were consistent throughout the trial. So yes, that would have been enough evidence to convict. Now, when it comes to the question of, may I have just a moment? Now, when it comes to the prejudice to the defendant, we must show that if he was prejudiced, as Your Honor knows, and the petitioner must show there was a reasonable probability, and then there was an unprofessional error in the result. So I would say that, yes, it is a mixed bag of law when examining the case. And I'm sorry if that is not the answer. I was trying to understand your question. I'm sorry.
Well, that's probably speaks more to my question than your answer, but let's jump to another issue, and that is the ex-wife's testimony.
Yes, Your Honor.
The ex-wife isn't there. She, kind of hears about this problem through the grapevine, and the officer talks to her. And his testimony is, well, she didn't seem surprised by this. What material fact does that tend to prove or disprove? What's the relevance of that testimony?
Well, that goes to the hindsight issue. Yes, there could have been an objection, but whenever they were in the moment and asking these questions, the attorney testified at the evidentiary hearing that what were his options? And you have to kind of look at it from his standpoint. At that point, he already objected to the hearsay. So then if he objects again, is he highlighting this issue more and making it more known to the jury? I'm sorry.
In other words, if I scream about it, the jury's going to look at me screaming.
Exactly, Your Honor. And whenever it comes to trial strategy and tactics, sometimes it's best just to sit down and not object, because then you're highlighting something for the jury that you kind of want to move on from.
But is that a roundabout way of saying it probably wasn't relevant to anything to begin with?
Yes, it could have been ruled that way. Yes, Your Honor.
As to the female minor that testified, it seems like that was, the defense. The defense opened the door for, I think there's a strong argument for strategic reasons. Respond to the pastor's testimony, right? The testimony elicited by the prosecution as to the pastor. That certainly wasn't a strategic move by the defense, and it certainly brought in evidence of a fourth witness.
Well, when it comes to the pastor's testimony, he was instructed multiple times, as is clear in the record. State pulled him out, and they did make objections. And what was the question, Your Honor, if I didn't understand? You just wanted me to talk about his testimony?
Well, yeah, I mean, the council didn't move for a mistrial. You had the pastor doing the testimony once, and I think that they instructed the pastor. I think the trial judge said, talk to the pastor, tell him to quit doing this. And the pastor did it again. And even after receiving, instruction from the court, it happens again. Defense doesn't move for a mistrial. Even though and obviously you can't say it would be crazy to move for, he moved for mistrial the first time. So
he moved for mistrial the first time. And as he testified in the hearing, that from his position in the trial at that moment, he didn't believe that he would be able to get a mistrial. There were no grounds for it, so he couldn't ask.
But he had just moved for mistrial on the same grounds.
He did, but he said that he didn't find that the court would actually agree to that, and he didn't find the grounds would be sufficient enough to ask for a mistrial.
So it's happened once, and the grounds were sufficient to make the mistrial. It happens a second time, admittedly making it worse. So by definition, 2 is worse than 1, right? Of the same conduct. So the same conduct that justified moving for mistrial once happens twice, and it doesn't move for mistrial. That seems.
If I may have just a moment,
Yeah, go
I'll
ahead.
check my notes. But again, even with, if he did move for, concerning the mistrial, I don't think it would have been, according to the record, it wouldn't have been granted. That was his opinion, and that was his. I'm sorry.
How do we know that?
Because
the
we
first
don't
time,
know that for sure.
The first time, we don't know that for sure. So the first time the judge declined to give a curative instruction. The second time the trial judge gave a curative instruction. So the trial judge thought it was worse the second time.
Yes, Your Honor, but whenever, again, in trial, you are going at a pace and a rhythm, and I think that he felt that reading the room, so to speak, that he wasn't going to get that mistrial. I wasn't there, and I can't determine what the circumstances were, but from reading the transcript, he and his testimony, he said that he wasn't going to ask for a mistrial because he didn't feel there were grounds, and that was his testimony, and that's what is in the record.
How do we assess whether there was a reasonable possibility the court would have granted mistrial?
Well, you would look at the Strickland standard to determine that.
I know, but under the specific facts of this case, how are we How would you apply that standard? It wasn't moved for, like, what would we have looked at for the trial judge to?
Well, the trial judge would first look to see, was it a tactical or strategic move? And obviously, counsel, even way before any testimony was heard, in the opening statements, he basically stated that he was going to go after impeachment. He was going to impeach everyone. So that, for instance,
But-
getting. Oh, I'm
But,
sorry.
but moving a mistrial wouldn't have stopped him from impeaching anyone. It was completely cost free. So you say, Judge, may I approach? You do it, the jury doesn't hear you. You come up, you move for mistrial. Right? I mean, there was no, you can't say it was like, well, he chose to do something else because it wasn't either or. He could have moved for mistrial at no cost whatsoever to any other strategy. And the trial judge had already indicated, I think this second time was worse because the trial judge had given a curative instruction that he declined to give the first time.
And again, Your Honor, it goes to the point that in that point in time, that attorney was handling this case and he saw that he didn't believe that he would get one. Again, I'm going based upon the attorney's belief at that time, when he was standing there having, trying the case, he said he didn't believe he had grounds. I don't know why he
Well, yeah,
didn't
but
believe.
I mean,
but
lots of people who commit ineffective assistance say, I thought I did the right thing, right? The issue is not, did he think it's the right thing?
Mhm.
The issue is, did he commit ineffective assistance despite doing the right thing? And what, so you tell me, well, he thought it was a good idea. That doesn't really answer the question.
Well, also, and I don't mean to
No,
interrupt. but
I don't, I'm not offended. Go.
Also, there's a ton of evidence that was used to convict him. So then you fail the prejudice prong because all this other evidence, testimony, in the Strickland standard, that goes to show that a mistrial would not have been granted because he wasn't prejudiced, basically, due to other testimony that was provided.
Let me ask you this, the defense's strategy was to try to make these witnesses look uncredible.
Correct.
That's his best route. If he succeeded in the minds of the jury that in making those, the three minor witnesses seem incredible, the fact that you now have a fourth person, could the jury not look at that and say, well, listen, that fourth person wasn't shown to be uncredible,
This comes down to what
right?
happened.
Like, yeah, I don't believe these three girls, but I got a fourth who they never attacked.
Yeah, but again, first of all, when it comes to this case, there were 3 victims. And this whole idea of accidental touching and so on. Okay, there was 2
Well, they
taps
say
on-
it's accidental. You say it was purposeful, right?
Yeah, we do, but I'm pointing out what the defense is trying to say is that there was no intent. So whenever they were trying the case, they had victim one, I'm sorry, she even said she had touched in her vagina and that he grabbed her and said that she felt something like pressure from fingerprints.
Yeah, but the point was, the defense was trying to show she was a liar, right? He was trying to show they made this stuff up, right? And so, I mean, I'm not saying they did, right? But that was the strategy.
Yeah.
Don't believe these 3 girls. They're not telling the truth. They got together, on the bus, right? They were talking about this and they made up this story. And when you have a fourth person, right, who was not shown to be uncredible, theoretically, in the way that the defense did, could that not say, well, man, he really did a good job attacking those 3 girls, but I got a fourth one who wasn't subject to those same attacks, and that puts me over the line.
But that was never a highlight or a feature of the state's case at all. So it was not even mentioned. And in his testimony, Pastor Tom kept saying and let's go back to the fact that whenever the whole issue about when the mistrial when they should have been requested, it's not very clear because there was multiple points in Pastor Tom's testimony that I couldn't tell from appellate's brief. Which instance? Was it the instance when state went over to the bench and asked, well, I'm going to ask these questions about what led to the physical encounter? That's what I assumed was the point. But if there was any other issues, it was because there was no citation and I couldn't determine which one. But to be honest, whenever the prosecutor did go up to the bench and say, before we go forward, he discussed, I don't want to have a mistrial, and said something to the effect of, you've opened the door to this and we're going to talk about what led to the fight. And what led to the fight was Pastor Tom saying, hey, I saw you molest these 3 girls, or I saw you get away from my girls, these sort of comments. So if we're talking about those comments, the state had to rebut what the defense was saying, if that's making sense. And if not, I can rephrase it for your honor. But the objection point was at the point whenever Pastor Tom was testifying about, hey, stop touching these 3 or 4 girls, what have you. And then let me back up 5 minutes. So Pastor Tom was observing the defendant doing whatever he was doing. He then has a scuffle with him, a shove. And then nothing is said about what led to the shoving. So then the state had to provide some sort of explanation. And that was that information about, well, hey, stop touching those three girls.
Going into jury deliberations, was there anything in the record that gave the defense cause to be hopeful they were going to get a not guilty verdict?
I didn't see anything in the record, Your Honor. And I'll have to double check, but I didn't see anything, Your Honor, to be hopeful about.
Any question?
The state would then ask that this court affirm the lower court's findings, and thank you, Your Honor.
Just want to try to hit as many things as I can here before my time is up. Judge Mize, I think the only time it makes sense not to move for a mistrial is if you think you're winning. And there is no evidence in the record that the defense attorneys thought they were. The irrelevant, highly prejudicial opinion testimony through the detective concerning his observation of the ex-wife. What was the jury going to do with that? No conclusion.
Well, counsel, respond to the argument he made, because I found that compelling, right? Because I don't find that to be, it's not like the wife said anything, like, you know, sometimes ex-wives hate their husbands, right? And you could tell them anything bad about them or vice versa, and nothing would surprise them, right? Like, we don't know what was going through her head, and the attorney might have just thought, I don't think this is relevant, but I also don't think the jury's going to pay much attention to it. But if I scream about it, they're going to pay attention to it, right? And I've been in court. I've declined to make objections because I didn't want a jury to think it was important, even though it was improper.
The only reasonable conclusion is she thought he did it, and that is inadmissible. That's not how you prove that someone has committed a crime.
Is
And
that the only reasonable conclusion from a facial expression of she looked nonchalant and unsurprised?
well,
Is it, how much are we supposed to assume a jury is reading into that?
even if
And
she
would they
hated-
not read more into it if I said, judge, stop him?
even if she hated him for some other reason, the evidence below was that he was a functioning alcoholic. There is no evidence in the record as to why she hated him. She could still be surprised that he's being accused of being a child molester, especially nothing good came out of this. It was inadmissible. It was irrelevant. It was highly
But counsel,
prejudicial.
nothing good may have come out of it, but because something worse have come from objecting, is my point.
I don't see how if they had caught it before the answer was given. Obviously, the state thought it was really important. They were going to get that evidence out there. With respect to the pictures and the video, very, very briefly, if defense counsel had shown up to court and given discovery in timely fashion, it's our contention that whatever evidence he had, and apparently it was photographs, still photographs showing people in the wave pool crashing into each other. That's what the prosecutor said. We believe that evidence would have been admissible. The problem was she couldn't examine her victims about it because they were already on the bus back to Brevard County or wherever it was. That evidence, please look at our video. The issue is not the effect of the waves on a 100-pound teenage girl. It's the effect of the waves on a grown man. And we selected a rescue diver who I believe testified he was about 200 pounds to go out there. We know that the conditions may not be identical, but this offense occurred, if it occurred at all, the first weekend following school letting out, and it was the 25th anniversary of Typhoon Lagoon. That place was probably packed.
Counsel, which witness could have testified that that video accurately depicted the effect of the waves on your client?
The state's my client, and I believe
Well, he said he was too blackout drunk to remember anything. He said, I don't remember anything that day. I was blackout drunk. It's all a blur. Which witness could have looked at that video and said, yeah, that looks about how it affected the defendant?
I don't know that the testimony would have been that specific as to the effect on Mr. Lauer, but the video could accurately reflect what the waves do to people, how close people are packed
Which
together.
witness could have testified what the waves do to a grown man?
Perhaps Pastor Tom.
Did Pastor Tom get in the pool?
I honestly don't remember
I don't
that,
think
Judge.
he did.
Please look at the video.
But how would you have gotten the video in is my question.
The state's problem with it was that it hadn't been disclosed and she couldn't ask her.
I know, but if it
witnesses
had
about
been
it.
disclosed, the next step would have been admission. If you couldn't get it admitted, the fact that it wasn't disclosed is harmless. Who would have who would have authenticated the video for purposes of showing the effect it had on your client?
Defense counsel would have had to figure that out if there was a possibility that it was coming in, but it wasn't because they didn't disclose it in timely fashion. I have 57 seconds here.
You're 50, that's 57 seconds over.
Oh, I'm so sorry.
Does anyone have any other questions?
Please watch the video, please write an opinion, and please reverse.
Thank you, counsel. Thank you. Bye. Next case on the docket is 23-1379 Florida BC Holdings LLC versus Jay Reese. Does anyone need a break? Yes, you're excused. Thank you, counsel. Judge Harper, you good work? All right, would the appellant please approach? Counsel, how much time would you like for rebuttal?
4 minutes, Your Honor.
All right, please proceed.
May it please the court. I'm Michael Orr, and along with Megan Comunale, we represent the appellant Synergy, who asks that this court reverse the trial court's decision not to grant directed verdicts or judgments notwithstanding the verdict motions from the appellant. We ask for that reversal for 2 reasons. First, the trial court erred in not applying the qualified protection privilege to Synergy's
Let me ask
act.
you this, in your brief on that issue, you spent a lot of time saying, look at all this testimony, right? That they had a qualified privilege, that they were trying to protect their own economic interest based on this agreement, right? If they did not believe they had an agreement, right? Just, I know you said this is not the situation with your client, just stipulate in a different case. Somebody is worried about one of their employees going to a competitor. They know they don't have a non-compete and they just make one up. Okay. You would stipulate they don't have a qualified privilege in that circumstance, right?
I think that would be much closer. Yes, Your Honor. And I think if the court were to look at the 3rd DCA's opinion in the Ethel Corporation case from 1976 and the Babson Brothers case from the 1st DCA in 1980, those fact patterns are a little bit more akin, and they
Yeah.
talk about sort of where the line is.
And that's my point, right? So juries can look at witnesses and say, I think that person's a liar. I think they're making this up. Juries get to do that, right? They judge credibility. That's a nice lawyerly way of saying they get to pick the liars and the truth tellers, right?
Yes, Your Honor.
Okay, so the idea that you had a qualified privilege was based on your client's at least belief that they had a non-compete, right? But the jury could just totally look at all your client's testimony and say, I disregard all of it. I don't believe any of it. I think they made it up.
And Your Honor, that's what the juries did in both the Ethel Corporation case and the Babson Brothers case. And the Ethel Corporation case, there was a 3-week jury trial where the jury didn't believe the defense. And the 3rd District Court of Appeal reversed and found as a matter of law, based on the facts, that the privilege should have applied. And that's what the 1st District Court of Appeal did in the Babson Brothers case. If the court looks at page 850 of that opinion, the court will find where the analysis was, even under these facts that the jury found did constitute improper means, there was a qualified privilege for the defense in that case and it should have applied such to bar the claim. So there are several instances that we've cited in the brief where you have those circumstances where juries will make a finding. And one of the interesting things about this case, Judge, and looking at the cases cited by both sides in the briefs, is I couldn't find a case where you
There was no
had,
signed non-compete,
what's that, Your Honor?
where they admitted they didn't have a signed non-compete.
Right, I didn't see a case like that. And I also did not see a case where it was based solely on misrepresentation. When you go back and read the cases, most of the case law that deals with this privilege issue and the improper means all relate to malice, making threats, illegal conduct. And a lot of the cases, and again, I keep harping on Ethel and Babson Brothers, they talk about this situation where typically when you're trying to interfere, you're intentionally interfering, you may have some malice, you may have some improper motives, but that may be mixed with a legitimate business interest. So counsel. Yes, sir. Are you suggesting that if, as the jury apparently found here, there was never a non-compete that was executed by that there still could be a qualified.
Even in the absence of finding that it was a motion.
Yeah, and answering that question, assume the jury found, because they could have, that your client knew there wasn't a non-compete, that they just made it up.
Both very good questions, and I think I can answer them in the same answer. One being that the particular verdict form that was used in this case never asked the jury for an interrogatory finding of whether or not there was a non-compete. But what it did, instruction, there was a specific instruction given to the jury that says the contract can be enforced even if it's lost or destroyed. The question on whether a contract existed between the parties and its contents is a question for you, the jury, to decide. Yes, Your Honor, that was. And implied in their verdict is that presumably they found that there was no non-compete. If there was a non-compete, then arguably your privilege would apply. In the absence of a non-compete, do you think we should write an opinion that says you can get this guy fired based upon a non-existent non-compete? Yes, Your Honor. In this particular case, I believe the instruction Your Honor is referring to is somewhere around the 2022 page of the record. And there is that one instruction that says it's an issue for you to decide. But of course, it's not on the verdict form. Regardless of that fact, what we have in this case is when Synergy sent its demand letter, all they had was Mr. Sawyer saying, I gave him this paperwork, I saw him sign the non-compete.
But you're assuming that the jury, that was true, and the jury could have just looked at that person and said, I think they're making that up, couldn't they? Juries get to do that. They can say, I don't believe this witness. I'm looking them in the eye and I think they're making it up. The jury could have found there was never a non-compete, couldn't they? And that your client knew there was never a non-compete. But you didn't ask for specific, jury questions on these things that I see. I didn't see a question as to, can you ask whether even if they find there was no non-compete, can you find that we believed there was a non-compete, right? We don't have that finding from the jury. You didn't ask for it. I think you were counsel below, but your client didn't ask for it. So it is totally true that the jury could have said, I think they're lying. I think they knew there was no non-compete, right? So given the verdict we have and the lack of a specific jury question on that, I don't think we can say it was like just established that at the time they sent that letter, they thought there was a non-compete. The jury's verdict shows the possibility that they did not think your client thought there was a non-compete.
I think that's absolutely fair, Your Honor, in that there wasn't an instruction or a request for a specific interrogatory verdict requested by the defendant appellant below. And on top of that, I agree, Your Honor, there could be a view of the evidence that perhaps there was testimony by Mr. Sawyer that it was
False.
that he was false, but there was no suggestion of that. There was no argument in closing. In fact, when
But the jury
doesn't.
doesn't have to disclose to you their deliberations, right? And
That's
you're
true.
prohibited from asking. Is there anything in the law that would have prevented the jury from going back to that room and somebody on the jury says, hey, I think that Sawyer guy was full of it. I just think he's a liar. I think that they knew there was no non-compete. Is there any reason that we can assume that didn't happen?
No, Your Honor, I think that absolutely could be one of the things that went through their heads when they rendered the verdict they did.
All right, so then your argument that we should find there was a qualified privilege here seems to me dependent on us finding that even when you know, because this is at least a possibility here in the eyes of the jury, even when you know there's no non-compete, you can send a letter saying, I've got a non-compete. I think it's lost, but I think it's enforceable. Fire this guy or I'm going to sue you.
Well, let me, I want to address one part of that, Your Honor. The testimony from Mr. Sawyer, and I believe it was somewhere around 2383 or 2382 of the record. Mr. Sawyer said explicitly that he saw Mr. Reese sign this document.
Correct, but he could have lied, right? Assume, don't challenge the assumptions, right? You admitted the jury could have just rejected that and said, I don't believe Sawyer, he's a liar. So given that they could have done that, right? In order for us to throw out this jury verdict, we would have to say that there's a qualified privilege, even when you know there's not a non-compete, to say you think you have a non-compete and fire this guy, would we not?
Close, Your Honor, but I don't think we have evidence in this case that he was lying. If the jury did in fact reject it and say he's lying, I don't believe it.
But it was your
Then
burden,
there's-
it was your burden to establish the non-compete. All they had, since there was no signed document, all the jury had to say was say, I don't credit his testimony,
Well,
right?
Your Honor, once we have that testimony that says that all employees, all sales employees sign a non-compete, which was undisputed in this case, all sales employees of the company sign those non-competes. Once we have that, and once we have Mr. Sawyer testifying, that's enough to meet our burden. When the other side comes back and is going to say, no, I didn't sign it, that'd be one thing, but it wasn't said.
Because it's enough to meet your burden for like directed verdict, right? But you don't get to decide what the jury accepts,
I agree,
Right.
Your Honor.
right? So, I mean, imagine you got, 6 people on that jury, maybe 2 or 3 of them work for a big corporation. And one of them says, hey, guys, my company screws up all the time. We've got all these policies and procedures. I don't buy that at all. I work for so-and-so company. You wouldn't believe the things I see every day, right? You represent a lot of big corporations. If I were to ask you confidentially, have you ever seen big corporations not follow their procedures? I think you'd probably say you've seen it a lot of times, right? I think every attorney would.
It does, Your Honor, and
So-
I think one thing we've got to remember for businesses is the executives that are making these decisions to send something like a non-compete, they have to make their decisions based on what they're being told by the people that actually did the act. So in this case, Mr. Sawyer is the one that sat with the plaintiff. He is the one that went over the documents and is the one that said he saw him sign it. So at the time they sent.
What you want us to do is to adopt a rule that says if an employer has a good faith belief that a non-compete exists, even if it doesn't, that's privileged if they then interfere thereafter with the subsequent employment.
I think that's fair, Your Honor, and consistent with the Ethel Corporation and Babson Brothers cases.
Can we switch over to the
Impact
second?
rule.
Yeah, let's talk about.
Can I ask one question before we switch
Sure.
gears? I would definitely want to switch gears. Counsel, but there's also, you said that the only testimony was Mr. Sawyer's testimony saying that the non-compete was seen, signed. But what about the fact that your checklist showed that it was not completed?
And the checklist was signed off by another managerial employee who testified under oath that he's not the one that gave it to him, and he would have not been the one to do that. It was Mr. Sawyer who gave him the documents, but it was the other managerial employee who filled out the checklist.
And
it
I
wasn't
guess I
checked.
just throw that out there to say, I at least see 2 pieces of evidence here, the testimony, the fact that it doesn't exist, but then also the fact we have a checklist that says it doesn't exist. So I don't know that we can get around the fact that the jury could.
I think what we're saying is a lot of your argument results around like, my client said this, and it just ignores the
Absolutely.
idea that not that your client, I'm sure your client's a great person, but juries are entitled to find people to be liars. And like, you got a jury verdict, they can find them to be a liar, right?
Yeah, so Judge, moving to
Let's
the
talk
impact
about- yeah.
rule issue, and Your Honors, in reviewing the case law for well over 100 years, the impact rule is applied in Florida. And what we find in reading the cases like the Holt case and like the Abril case from the Florida Supreme Court are certain very narrow recognized exceptions to the impact rule. And one of the interesting things about this April case, Justice Lewis wrote the opinion and it was a fractured opinion with concurring opinions and dissents. But one of the statements made in that opinion was, as we have noted, the impact rule does not apply to any intentional torts. Cite. And then they cite the Roel versus Holt case and a footnote from that case.
I mean, but it didn't say that.
And the footnote didn't say that. And what's interesting about that footnote, Your Honor, when you read the footnote and they cite to 3 different types of cases: defamation, invasion of privacy, and intentional infliction of emotional distress. They cite the 3 cases. One of the cases was Eastern Airlines. This is a case where a man got on an airplane. It was leaving Miami. It had 3 engines. The engines went down. They had to turn around back to Miami. One engine came back on. They were able to land. He sued the airline, wanted intentional infliction of emotional distress. The court found that the conduct wasn't even outrageous enough for intentional infliction of emotional distress. The impact rule wasn't even discussed. But that's a case that a footnote in dicta and Roel cited.
Counsel, let me ask you this. So there's
Yes.
2 ways to look at this, because I think we're all interested in the impact rule argument, okay? One way to look at this is to look at Abril and say, was that dicta? In other words, did the Supreme Court really mean to take the impact rule away from all intentional torts, to roll it back? Right? The other way to look at it is, did it ever get there in the first place? And here's what I mean by that. Florida's a common law state, right? So the very first statute in Florida says, like, the state is established, right? 1.01, and here's the metes and bounds of the state, right? 2.01 says the state of Florida adopts the common law of England as of July 4th, 1776, except as abrogated by statute. That's why we're a common law state, because we adopted it pursuant to statute. Okay. As of July 4th, 1776, the impact rule didn't exist, right? It was made up by the Supreme Court in the 1800s. Okay. They get to make stuff up. We don't get to do that. They get to make stuff up, right? So one way to look at it is to start with the impact rule in April and say, did they mean to take it away? Another way to look at it is, did it ever get there in the first place? You know, looking at the origins of the impact rule, has the Supreme Court ever extended, when they created it out of nothing, did they ever extend it to cover a claim of this nature? Can you?
Good question, Judge. And in that case, 1893, the International Ocean case, a gentleman was waiting on a telegram about his wife dying, and it got there late. He missed her death, and ultimately
You're in your, take all the time as you want, just in your rebuttal.
I'm going to just very quickly, Your Honor. And ultimately, the court started the impact rule, and then you had cases over the years like Peacock, LRX, Sherwin, that have been cited in the briefs, where the courts have applied the impact rule in intentional tort cases. And the analysis that's been through all these Florida Supreme Court cases as to the impact rule is when a narrow exception is going to be applied. In that particular instance, Judge, we haven't seen one, and I believe the LRX case is the case where you had a jury verdict that was reversed, and the court had to determine how the verdict form was going to read when it was remanded. And they specifically pointed out to the trial court, you need to separate defamation and your intentional interference claim, similar to the one we have here, because they have different damages. You don't get emotional distress you get it in defamation, but you don't get in the other, as the court found in the Miami Herald versus Brown case. And I'll reserve the remainder of my time. Thank you.
Are those your 2 best cases for that issue, counsel? The idea that, because before we have to decide what's rolled back, that it was extended to cover these types of claims, LRX and the Miami.
Well, not LRX, the Peacock case, Your Honor, from the first DCA in 1983. And the Sherwin case discusses this from the Middle District in Tampa. And then all the Florida Supreme Court cases that analyze it, with the exception of the dicta in April. Thank you, Your Honor.
Wait just a second here. All right, go ahead, counsel.
Good morning, Your Honor, and may it please the court. My name is Scott Adams, along with my co-counsel, Mr. Ryan Labar. We represent the appellee in this case, Mr. Jay Reese. On this appeal from his prior employer, Synergy Equipment, challenge of the jury's verdict of their intentional interference with his prior employer that was improper is the jury's conclusion. That's the first point on appeal. The second point on appeal is the jury's award of emotional distress damages because of that intentional interference that was improper. This court should affirm on both of those points.
I'll just jump right in. I know we were on the impact rule, as opposing counsel was sitting down. I wanted to just start right there. The case that I'm looking at, the Reed versus Daly case out of the first DCA. It seems your position puts all the eggs in the basket that the impact rule does not apply to intentional torts. And if I misread that, please stop me and say, no, Judge, you totally missed our brief. That was not our position. That was my read of your position. Am I at least close to what your argument was?
Yes, Your Honor.
Okay. So we get a case like Reed versus Daly out of the first DCA. Are you familiar with that decision? Would we have to certify conflict with Reed versus Daly if we follow your line of logic? Because it appears Reed versus Daly specifically said there are intentional torts in which you do apply, and that the test isn't an intentional tort or negligence. The test is whether the type of conduct described by the tort creates foreseeable harms, which be predominantly emotional rather than financial in nature. So we have to say, before Supreme Court will start to find conflict with Reed if we follow your arguments here today.
I don't think the court has to certify, because the application that they applied was a foreseeability under the impact rule. Back to what the court has already discussed, the question is, has the impact rule ever reached intentional torts?
But
in their
well, I mean,
entirety?
obviously Reed says it does cover intentional torts. It gives a list of some intentional torts where it was covered. Why would we? That's why I'm, and looking at your argument is it doesn't apply to intentional torts. Reed seems to say, here's some intentional torts where it would. The test is not even intentional or negligent. The test is look at the action itself, look at the cause of action. Are the damages predominantly financial in nature or emotional in nature? If emotional, then the impact rule would not apply if financial. So wouldn't we have to certify a conflict with a case like Reed?
It seems, Your Honor, that the Reed decision is based on the major premise of the foreseeability, then the extending to the intentional tort, the way that I read the case in its entirety. So therefore, the court would not need to certify conflict. But if it is interpreted to say that the primary holding is that the impact rule is applying to intentional torts, then yes, it would have to.
So then should we apply the foreseeability in this situation, just like they did in Reed?
Sure. Our position is you should not, Your Honor. Again, it is intentional, and that's where you stop. If the court did apply foreseeability, I did cite that it was foreseeable in this case, the Scott versus the Otis elevator case, which is in a different context, and I understand that. But the court there trying to determine whether or not mental anguish damages were awardable under a statute 440.205. They looked at common law cases for intentional torts from other jurisdictions. And the court found that it was foreseeable that mental anguish damages would be awarded in an intentional tort, which they made the analogy that 44205 was an intentional tort.
But the impact rule was never discussed in the Scott case.
That's correct, Your Honor.
So how can we say that the Florida Supreme Court grappled with the concept when the issue was never raised? I mean, typically, if I'm looking at a case and I can't find that the issue was ever raised, I have to assume nobody made the argument. So therefore, I cannot take that case to stand premise because the argument was never made. I mean, am I wrong on that? Was the impact rule ever raised in the Otis case?
It was not, Your Honor. And again, I cited for the proposition strictly for foreseeability. But I also cited the courts in a tortious interference case, specifically a tortious interference case, to the restatement that also allows under the restatement of law that in a tortious interference case, that mental anguish damages as well as damage to reputation are foreseeable if the evidence would support it.
So counsel, this kind of takes me to really, I think, the heart of where my analysis is going with this. And maybe I think where some of the panel members are going with this is, or maybe thinking through this as well. If we do apply the foreseeability test like they did in the Reed decision, and like potentially you could say that, I mean, there's arguments, I know you all both making arguments both ways, whether or not there's whole hog, you can't have intentional torts, but if we do apply the foreseeability test, even in the intentional tort context, what is your argument that the predominant damages and interference, a tortious interference of advantageous business relationship, that the predominant damages flowing from that in a typical case are emotional rather than financial? Are you telling us that your position before this court would be when somebody files a tortious interference with advantageous business relationship, what they're really seeking is their hurt feelings, not money for the fact that they lost a contract, they lost a job? Would that be your position?
No, Your Honor. Specifically on foreseeability, which is typically under the law is a jury question.
So I just want to be clear. If we did apply the foreseeability test, your concession before the court, and you're saying, don't do it, Judge, don't do it. I get that. And I'm going to let you go after this one. I'm probably not going to ask any more questions. But you would concede that a tortious interference of advantageous business relationship, if we did use a foreseeability, predominantly we're talking financial rather than emotional damages in a tort like that, correct?
It depends on the facts of the case, Your Honor.
Well, then that brings up another question. Do we really truly focus on the facts of is in any of these cases in which they've carved out exceptions? Have they said under the facts of this particular case, or do they look at the tort itself? When the Florida Supreme Court's answering these certified questions of does this particular cause of action fall within, does the impact rule apply? Do they say when they're certifying those questions, does it apply under these facts, or do they say, does it apply to this tort? Do you have any cases where they say, oh, it applies only to, this particular cause of action under these facts, or do they look at the tort itself?
I did not cite any in my brief, Your Honor. I know there are some cases where they're carving out the exception, such as the medical malpractice cases or childbirth cases, the dead body cases.
But those are whole torts, right? I mean, those are entire actions. Those are not particular cases. I mean, in the Abril case, the Rowell case, both of those, they're talking about specific torts. The impact rule, does the Abril case, is Florida's impact rule applicable in a case in which it is alleged the infliction of emotional injury has resulted from a clinical laboratory's breach of the duty of confidentiality under Section 381 with respect to HIV test information? Particular tort, HIV test. We don't go into the specific facts of that particular case, correct? We just say if we have this tort, we don't say how was this particular plaintiff hurt? How did this particular plaintiff feel? Right? We look at this particular tort that they
Well, in the Abril case, yeah, it is a tortious interference, right? That is the basis of what's occurring to some degree. They are looking to some specifics, would be our position and our argument on it. And so back to the predominantly issue and the foreseeability that the court was pointing to. In this specific case, you have mental anguish damages awarding that were predominant over the economics. It was 36,000 versus 50. So
Counsel, could the answer be different for different causes of action? And what I mean by that is you have a cause of action, like what was at issue in April, where inherent to the cause of action is that the damages are always going to be emotional, and there's not going to be a factual scenario under that cause of action where you're wondering whether the damages are primarily emotional versus financial. Whereas tortious interference with a business relationship, it really could be drastically different fact by fact. That could cover, two large companies or small businesses who lost one contract that didn't affect their overall lives. It could also affect like a car salesman, right, who had built up some, some group of customers that were loyal to him, and when he moved dealerships, all right, you put that guy out of work, and the missing a couple months of pay is nothing compared to the terror he's going to be looking at his kids, knowing he can't feed them for those 2 months, right? The actual 10 or 15 or $20,000, whatever it is, he misses until he gets work is nothing, is just inherently nothing compares. So in the tortious interference, it could be really fact specific. Whereas there are some claims where the claim inherently is not going to be fact specific in terms of just by the nature of the claim, the damages are going to be emotional and economic. Whereas that can't be said about costs of action.
We would agree, Your Honor. And now I understand the court is trying to formulate a rule, or what rule does apply in its entirety here with regards to the impact rule. Can one be, you see the court struggling at the Supreme Court level, carving out what it's referring to sometimes as exceptions. They also make these statements about exclusions. Our position as the brief, as the court has already identified, is that the impact rule in and of itself is excluded from, intentional torts are excluded from the impact rule.
So
That's what,
counsel, is it your position that when a Brill said the impact rule doesn't apply to any intentional tort, that's the same as saying that every intentional tort entitles you to emotional damage?
it is, Your Honor, that is our position. And you have to read Averill that broad in order for it to be read in context to the other cases cited by the appellant in their briefs. Those cases, such as the 2019 case from the First District Court of Appeal, where they're focusing on these issues of predominantly mental anguish damages, or that they apply to intentional torts that warrant punitive damages.
If we read it that broad, that the inverse of the impact rule doesn't apply to any intentional torts, does it mean that emotional damage is recovered in every intentional tort? How do we square that without conflicting with these other cases that Judge Smith has mentioned?
I think the court could simply cite the Averill decision. Moving forward with that,
Well, counsel, we can't just cite it. If we're in conflict, that's something we would not be doing our duties to discuss, given that we have a duty to certify conflicts,
yes.
right? One of the duties we have as a DCA is to create jurisdiction for the Florida Supreme Court. That's on us. We are a gatekeeper for the Florida Supreme Court. We, to a certain extent, get to decide when they do and don't have jurisdiction. And so to just say, like, don't worry about the conflict, like, we're not gonna, I'm telling you right now, we're not gonna not worry about whether there's a conflict, like.
Yeah, the best answer I have for that, Your Honor, is to try to distinguish it on the grounds of the applied foreseeability test, which should not have been applied based on Averill. If that gets it to be a conflict, then conflict would need to be certified at that point. I would say this as well: if the court did not want to answer the issue of the impact rule, even under these other tests to be applied, I think the court could sustain the jury's verdict on the mental anguish damages. As I said, mental anguish were the predominant damages awarded. So those cases that would say intentional torts that result in primarily emotional distress damages are excluded from the impact rule. This case would meet that based on the jury's verdict and facts of this case. Likewise, those cases that say the punitive damages would be warranted. And I'll transition into the first point on appeal with this. I think
Counsel,
looking at,
before we get out of this one issue, if you don't mind, so the Averill case, I know we're quoting this sentence in Averill that states where the Supreme Court says, we have noted that the impact rule does not apply to any intentional torts. But that's not the whole sentence. The whole sentence is, for example, we have noted that the impact rule does not apply to any intentional torts, comma, such as defamation, invasion of privacy, intentional infliction of emotional distress. By that sentence alone, can we really say that the Florida Supreme Court is saying no impact rule in any intentional tort? Aren't they particularly describing and pulling out intentional torts here that obviously have a primary emotional impact, invasion of privacy, intentional infliction of emotional distress, and by its own wording, that one obviously can be emotional primary. Defamation, where you're defaming someone's character. I mean, what the list that they seem to provide is 3 torts that are primarily, predominantly torts that are emotional rather than financial. And then they cite, don't they cite Rowell versus Holt for this statement? Note footnote 1, which is again a Florida Supreme Court case. That case once again says that footnote that the impact rule does not apply to, and this is what gets me with this. This is where I'm having a hard time saying Averill just knocks out all intentional torts. The impact rule does not apply to recognized intentional torts that result in this foreseeability test, predominantly emotional damages, including the intentional infliction of emotional distress. Has Rowell ever been expressly receded from by the Florida Supreme Court? Other than this sentence that seems to affirm Rowell, has it ever been, anybody ever really truly expressly receded from Rowell and the foreseeability test that appears to have to apply even in intentional tort settings?
There's a sentence after that, Your Honor, right, in the Rowell decision. And as the court made the statement in reading it, it's any intentional torts, right? Not the intentional torts of. And given the language, it's plain meaning, any means any.
Counsel, hold on. Do we give cases their plain meaning? Cases aren't statutes.
Correct, Your Honor.
Okay.
So the interpretation would be different, as the court has already recognized. It's common law at this point, and that goes to the court's question of, has it been extended that far? And our position is it has not. In the whole footnote, it says, while the case law is not clear, intentional torts are excluded from, not exceptions to, the impact rule. That's in 2003. If you look back at other cases, a case cited by the appellant, the Laporte case, it's Laporte versus Associated Independents. In that case, the Supreme Court is talking about the Kersey decision. And there the court says the Supreme Court reversed the judgment and undertook to distinguish cases involving mental suffering from intentional or malicious torts, and those in which mental suffering may have resulted from negligent acts. And it moves forward and says, and it's quoting from the decision, it says, this court acknowledges its commitment to the rule that there could be no recovery for mental pain unconnected with physical hurt in an action arising from a negligent breach of the contract when simple negligence is involved. That is the breach of reasonableness that we put up against a reasonable person, not the standard of intentionality that's applied either to the tortfeasor themselves, whether it be a person or an individual, or to me, a person or a corporation. And I cited the court to the Second District Court of Appeal decision in Rivers versus Grimsley. There, the court clearly said the impact doctrine has no, it's a Second Circuit case, not a Supreme Court case. The impact doctrine has no application to intentional torts. And its justification there, they say, because the duties created by these torts have never been restricted to the protection of physical personal property. Again, intentional torts, the impact rule was never meant to cover intentional torts. They are excluded from that. Now, in this case, as I was saying, that even if one of these other rules did apply, whether it be the foreseeability test of predominantly mental anguish or to warrant punitive damages, the facts in this case would fall under either one of those tests if the impact rule was extended, and those were exceptions to that. One, I've already said, the jury verdict here awarded predominantly mental anguish damages. Second is, as the court was talking about the first issue in this case, the evidence, the jury could have concluded that express malice was present. And so on that first point, even if the court was to determine that a qualified privilege was present, the jury could have found express malice present. Obviously, our position is there was no privilege because there is no non-compete, and the evidence warranted that conclusion by the jury. But also the facts of this case are, as the court pointed out, that there was a new hire checklist that was created by the employer to mark off the documents that came in from the new hire paperwork. And that paperwork was gathered by the individual who hired Mr. Rob Thompson, who testified at trial. He put together the package. Now, the issue of who he gave it to, whether he gave it directly or not, was that.
Counsel, if I may pause, because I know your time appears to be up, but so if we were to, just like in the Abril case and the Rowell case, if we were to phrase what you're saying, okay, Judge, under these facts, because I will concede, if you look at the Abril case and the Rowell case, the way they word their particular torts is they do add some extra facts to them. They add some facts to they don't just say any legal malpractice results in, no impact rule, it's a legal malpractice where you've got a pretrial detainee resulted in a protracted period of wrongful, so on and so on. And the court is pretty specific. They do put a couple extra facts. How would you phrase it? How would you phrase this particular tort in such a way that we could write it out like has always been certified up to the Supreme Court? Supreme Court, we want to certify you a question.
Would it be tortious interference committed with actual malice?
Yes. How exactly would you have us word it to the Supreme Court if we were to certify a question under a tort worded however? And I'm going to give you the floor to tell us how we write this to the Supreme Court.
First, let me say, Your Honor, I would have a more precise definition if I was prepared exactly to write the certified question. But I think it should be phrased in a manner, if it was certified, that in a tortious interference case where the evidence was sufficient for a jury to conclude, express malice, does the impact rule apply? And in addressing it.
Wouldn't that require a finding of malice on the jury's part? I mean, there are intentional torts and then there are intentional torts. And I know that doesn't make a lot of sense, but I think we all know what we're talking about. And there's no finding of malice here, except to the extent that it's inherent in a tortious interference, that you didn't do it, out of niceness, you did it. But there's a lot of privileges too. So you can be unpleasant and still, be privileged to do it. So I think if we were to certify a question and ask them about malice, that wouldn't really help us much because there's no finding of malice here by the jury.
That's correct, Your Honor. There is none. The defense of the qualified privilege was not put forth on the verdict form. In that context, the case was argued under the rubric of the proper, improper, and applying the privilege itself. Our position was that.
But you would concede that the issue of the impact rule was raised. I mean, that was a summary judgment basis for the defense below, wasn't it?
It was, Your Honor. Yes. Yeah, we're not contesting that was not raised.
Did anyone ask for a malice instruction?
No malice instruction.
Do we know whether the jury found malice?
We do not.
They could have found malice.
They could have found malice, is our position based on the facts.
Thank you, counsel.
Yes.
All right, rebuttal.
Thank you, Your Honors. In my limited time, I'm going to address a question from Judge Smith about the scope of the Supreme Court's holdings, and the last question from Judge Orfinger that deals with the malice issue. Turning first to Judge Smith's question, we look to the Eaker case. The Supreme Court, and I believe it was Justice Lewis again, did what they've done a number of times, where they get a certified question and they actually rewrite it to make it more narrow because they're concerned about how broad it is. And so a lot of these opinions, Eaker, Abril, Rawl versus Holt, the certified question and the resulting holding that you have is usually very narrow, and it's a cause of action based on a very specific set of facts. And for example, in that Holt case, you had a legal malpractice claim against a public defender, and the individual prisoner was saying, hey, my rights have been restored. I have a document. And the public defender just lost it, didn't look at it. And he was in jail for a short period of time, and he was able to maintain action. And the court said, under those very limited facts, we're going to permit this, and the impact rule won't apply for that legal malpractice claim. So that is what the court has done time and time again. As to the malice issue, Judge Orfinger, the question on the verdict form, and actually the entire trial, openings, closings, was all about improper means. There wasn't argument of malice.
There was no evidence of malice. There's no finding of malice. The first question on the verdict form was about improper means. And when we go to the case law, it's malice is a separate issue or improper means. There was no argument of malice. There's no finding of malice. There's no evidence of malice. This was all about the misrepresentation issue, which is one of the things that can be found under improper means. And I go back to it again. I know the court is not enamored with the first issue, given the questions today, but I can't find a case where there's a misrepresentation in connection with the improper means analysis, and that's it. And then all of a sudden that becomes a basis to get around the privilege.
Well, but doesn't that assume that the jury thought it was a misrepresentation and not just a flat out falsehood? And we don't know whether it was an honest mistake, a mistaken belief that there was an open compete versus just a flat out falsehood. And I'm not suggesting either one, but we can't tell from the verdict
You're right.
what the jury thought.
You're absolutely right, Judge. But my point again, and now going back to the impact rule, if we're analyzing the cases, there is no malice in this case to look.
Can we certify it to the Supreme Court saying in a case where no malice, where we don't know whether there was malice found? Like, you're right, there's no finding of malice, there's no finding of not malice.
Yeah, and Judge, again, on that issue, I think if we looked at the Babson Brothers and the Ethel Corporation cases and the analysis they have on page 1225 and page 850 of those opinions respectively, I think that gives us the analysis for the court to do exactly what we're asking for the court to do.
How would we certify that? I'm going to give you the chance to tell us, okay, so we're writing a question.
As to the impact rule?
Yes, and under the tortious interference with the advantageous business relationship, what extra facts do we throw on there? Because I mean, your case is not just a tortious interference with advantageous business relationship. There's some extra facts here. It's not just, I attacked somebody's contract. There was an employment relationship. There was, allegation that document that was never found, somehow caused this man to lose his job. But how do we phrase this question to the Florida Supreme Court, whether we find in your favor or not?
We don't want the Florida Supreme Court to have to narrow our question. We want them to say, we had to narrow the first question, the sixth, we're taking it as is.
It's a great question, Your Honor. And I've in writing the brief, I actually thought this is one of those instances where you're really dealing with two questions. You've got the issue of, did the Florida Supreme Court in Abril decide that the impact rule doesn't apply to any intentional torts? That's a question for the Florida Supreme Court to answer, because
that's
it
an easy one
appears,
to write. But the second question would be,
I would agree with that. It is indeed. And then the second one would be, in a case of intentional interference with a employment contract, does the impact rule apply to bar a claim for emotional distress damages? Question. And in this particular case, Judge, I just want to address very quickly, because I think I'm out of time.
I gave him 3 extra minutes. You can go.
Thank you, Judge. The predominance issue, when we go back through the case law in these Florida Supreme Court cases, they're talking about where you're only going to be able to get emotional distress damages. They're not talking about cases where, like in this case, you get a $36,000 award for the 30 days you were out of work. That's an economic injury. Those are economic damages. And just because a jury gave slightly more money for emotional distress than they did for economic doesn't mean it's predominant under the case law.
Counsel, couldn't that be fact specific? I mean, if I told you tomorrow, you don't have any savings, all right? You're fired. You don't know whether your kids are gonna have a place to sleep tomorrow night. Okay. 2 weeks later, you get in the job and everything ends up being fine. You tell me that 2 weeks that you spent wondering whether your kids were gonna starve, whether they're gonna sleep outside, couldn't be much worse than the 2 weeks of lost wages.
It could, Your Honor, but I think in this
And couldn't
particular,
somebody know that in advance, depending on who they're doing it to?
potentially, and the analysis is on the plaintiff side. I mean, you've got somebody that was out of work for 30 days before they got another job and came and testified that they lost some sleep and had some issues with their wife, but there's no treatment, no medical treatment, no seeing a psychotherapist, a psychologist. That is what the Florida Supreme Court was worried about when they wrote the impact.
Maybe he didn't have insurance to pay for those things. He didn't have a job.
There's no evidence of that, but that's possible, Your Honor. And that would go back to Your Honor's point of it being potentially fact specific.
Thank you, counsel.
Thank you, Judge.
All right, Counselor excuse, thank you. You guys want to talk through? 23-230. Board of Farm Bureau Casualty Insurance Company versus the estate of Randall Lee Taylor by and through its personal representative, Marcia Taylor. Council, how much time would you like for a rebuttal?
5 minutes, Your Honor.
All right. Please proceed.
Thank you. Hinda Klein here on behalf of Florida Farm Bureau. We have raised 2 issues on appeal. The first is that the trial court erred in denying our motion for summary judgment on the application of the pollution exclusion. And the second, that the trial court erred in granting the plaintiff's motion for summary judgment.
Did the court grant the plaintiff summary judgment?
Yes, that's how we're hearing.
Well, I see the order you appealed. I don't see anywhere it says the words plaintiff is granted summary judgment. And I was frankly, maybe I just missed something. I was perplexed as to why you thought that. And I was perplexed as to why the other side accepted it in their briefs. I looked at the order a lot because I found it really interesting. And I could not find anywhere in that order where the court said summary judgment granted in favor of the plaintiffs. I see the court saying, based on the evidence presented to date, I think the bacteria exclusion of the bacteria rider applies. Oh, and therefore summary judgment to the defendants denied. I don't see anywhere in the order where the court says summary judgment is granted to anyone. I don't see where the court said you couldn't argue at trial that the bacteria did not apply.
I
Am I
understand.
missing? And I see a transcript where the court said, I don't think I can grant summary judgment here. This isn't prompted. This isn't framed to where I can grant summary judgment. And then I see an order that nowhere in it says summary judgment is granted to anyone.
They don't use the court did not use those words. I agree, Your Honor, but what it did say is that additional coverage, the additional coverage for fungi provides coverage for the damages claimed by the
That's a
plaintiff.
finding, right? Where does it say summary judgment is granted to the plaintiff on that ground? Where does it say you can't argue that at trial? It says based on the uncontested evidence presented to date, the additional coverage for fungi bacteria provides coverage based on the uncontested evidence presented to date. Does not say there can't be more evidence presented at trial, does not say plaintiff has summary judgment.
Well, I don't understand why the court then would say there's coverage for the damages.
But
The
if
whole
the
issue.
court says I think there's coverage and therefore I'm denying your summary judgment, that is not the same as granting summary judgment to the plaintiff. Like those are just 2 different things. One means I'm on that basis, I'm denying their summary judgment. Now you go to trial. The other means summary judgment is granted and therefore you don't get a trial, right? Nowhere in here does it say there's not going to be a trial. It doesn't say you can't present further evidence. It doesn't say anything like that.
But the second to last sentence of the court's findings, based on the foregoing, the additional coverage for fungi, wet or dry rot or bacteria provides coverage for damages claimed by the plaintiff.
Correct. The court made that finding and as a result denied your motion for summary judgment. That does not just the court making a factual finding in an order and then denying somebody's motion for summary judgment because they find that fact or that legal conclusion defeats your motion for summary judgment. Does not mean there was a motion for summary judgment for the plaintiff pending, does not mean the court is granting summary judgment. If the court wanted to say summary judgment granted, it could have done so. I've been a trial judge. I never granted summary judgment without saying the word summary judgment granted it. Have you ever appealed a summary judgment order granting summary judgment that didn't contain the word granted in it?
No,
Have you aware of any case in the history of the state where a court found somebody granted summary judgment without using the word granted?
no, I can't say I know of one. Judge.
Okay,
No.
I don't think this order grants anybody summary judgment.
Ms. Klein, let me ask you this. I mean, the horse your client was riding was the pollution exclusion.
Mhm.
And once the judge said that doesn't apply, weren't the parties free to stipulate? Essentially, they stipulated that based on the ruling so far, the pollution exclusion doesn't apply. And the fungi, bacteria rider provides coverage, so there's nothing left to fight about except the legal conclusion of the trial judge on the summary judgment. I mean, I guess I understand the point that Judge Mize is making, but I'm trying to understand if the parties essentially didn't stipulate that there's really nothing left to fight about except these legal issues.
Well, and that's how I always construed this. It's actually never occurred to me, Your Honor, that this didn't grant
Did
the
nobody like,
summary judgment to opposing counsel on that issue. I don't know how you could construe an order that says the plaintiff has coverage under this endorsement.
well, really easy, because it says based on the uncontested evidence presented to date, I find this rider applies. It doesn't say it can't go to trial. It doesn't say the word summary judgment granted. And the judge said at the hearing, I'm not granting anybody summary judgment.
Well, I don't think that she actually said that. What
She
she
said, this
said
is not
was,
framed to where I
it's
can act.
not
I
framed.
don't think I can grant
Correct.
summary judgment. And then she entered an order that contains the word summary judgment granted nowhere.
that's correct. I
It looks to
can't
me like
refute
you
that.
lost summary judgment, had a right to go to trial, and instead stipulated entry of a judgment.
But we still have the issue that the court found that there was coverage.
Correct.
And
Denials of
this is
summary
a
judgment
breach
are not appealable. You entered into a stipulation that said, we reserve the right to appeal anything properly appealable. I forget what the language was. You didn't have anything properly appealable because denials of summary judgment aren't appealable.
Respectfully, Judge, I still think that this order does dispose of the coverage issue. I don't know how else to read it, Your Honor. I have to disagree, but I also can't disagree with the court with respect to the absence of the word summary judgment is granted.
Did anybody ask the trial judge? Anybody file a motion to clarify, like, has summary judgment been granted? Are you telling us no trial?
No,
Okay,
No.
so the trial judge, there's never anything where the trial judge said you don't get a trial date, right?
no. No.
Okay, so until you all entered your stipulation, you remained on the trial track?
Honestly, I don't know. I really don't know, Your Honor.
I think the record reflects that you did until you all stipulated, and the judge entered an order based on their stipulation. I'm taking it off the trial calendar.
Well, I mean, at that point, at the time that the court entered the summary judgment or the order that we are seeking to appeal, at the time that the order was entered, there was still the issue of damages. So it wouldn't be surprising that it remained on the trial docket. That, I don't think that that's dispositive of the issue of whether the court, in the court's mind, maybe disposed of the
Ultimately,
coverage.
you all stipulated the damages on the.
Correct.
$30,000.
That's the only thing we stipulated.
Correct.
We didn't stipulate on the bacteria endorsement. We didn't stipulate on the pollution exclusion. We stipulated simply because we believe that the court found coverage one way or the other. And under those circumstances, you know, that we didn't feel that there was a need for a trial.
Well, let's lay aside the procedural problems that we've got, and, you know, I think Judge Mize makes a good point. And I can't dismiss the point, although I understand why it was done. But let's just talk about the merits for a minute. I take it that on the identical exclusion on relatively similar facts, you think that the Fifth District, a court that was rarely wrong in my experience, on that, made a grievous mistake in the Worrell case.
Yes.
And so to rule in your favor, assuming that we can somehow overcome the procedural obstacles, we have to essentially conflict with the Fifth. Is that right?
Yes.
Okay.
Yes.
I mean, you don't see any principled basis for us to disagree with the ruling of the Fifth without certain.
I don't see how you could on the pollution exclusion issue.
Judge Orfinger on that panel.
No, that's not. So between Mr. Nation and I, this is round two, and just for court's edification, we are seeking Supreme Court review of the Worrell decision.
I wasn't surprised,
So-
having had the privilege of you and Mr. Nation in front of me. I'm not surprised that either one of you want to drive to Tallahassee.
But does that mean Worrell isn't final? Is the mandate not issued?
The mandate, which you have to leave.
Well, because the reason I ask, and I don't know the answer to this, if there's no mandate, it's not precedential. we would be certifying conflict because there's technically no opinion.
We did not move for rehearing, so I assume that the mandate is issued.
I know, but you can move to withhold the issue if it's a mandate pending Supreme Court review.
Under the circumstance, since it wasn't, you know, a large judgment, there didn't seem to be a reason to do that. I guess if the court will entertain argument on the issues on appeal, I believe that the trial court erred in denying our motion for summary judgment because the pollution exclusion at issue is not ambiguous. Contrary to the court's conclusion in this case that the proverbial man on the street wouldn't understand the pollution exclusion to exclude coverage for a decomposing dead body. It's beyond dispute. Denny court clearly and unambiguously said that the pollution exclusion is clear and unambiguous. And the cases that we've cited, a number of which are from Florida Middle District Courts, which of course is not precedent, but the pollution exclusion has been applied to a number of bodily functions such as feces and urine.
Counsel, isn't feces literally waste? We refer that as the bodily waste.
Yes,
Feces is waste excluded by the body.
correct.
The body itself is not akin to feces, right? Feces is literally waste.
Correct. Yes, it is.
Nobody, so living people would sometimes do refer to feces as waste. Nobody refers to their body as waste.
No, that's true, but the pollution exclusion is a little bit broader than that and excludes coverage for damages caused by irritants, contaminants, and waste. So it doesn't
Have you ever heard
necessarily.
of anybody refer to their body as an irritant?
No, I haven't, but
Have you ever heard anybody refer to their body as a contaminant?
well, I believe hospitals probably refer to people's bodies as contaminated.
Contaminants?
Well, in the sense that they contaminate other people, or they could contaminate.
Their
other people.
bodies do, or things that get excreted from their bodies?
That could be both. It could be both. That's why people in hospitals often have all kinds of protective gear. And in this case, of course, the decomposing body was cleaned up by a remediation company, not, Stanley Steamer or something else.
Don't the examples under the pollution, now I agree that it has some broad language, any solid, liquid, gaseous, or thermal irritant or contaminant.
Mhm.
But then it gives us some specific examples that I think help inform our decision. Smoke, vapor, soot, fumes, acid, alkalized chemicals, and waste. I mean, if I understand the facts of this case, this fellow wasn't discovered in his home for a while, and fluids leaked from his body and contaminated the premises. So, I mean, don't those examples, soot, alkalis, and that sort of thing, help inform us as to what the exclusion was intended to cover?
Well, the Denny court said, our decision today is not limited to those kind of environmental issues. And the, courts since then have rejected the adjucendum generis line of cases that talk about, an example is in the Hirshhorn case, they addressed it and rejected it. And the Philadelphia versus Yachtsman Inn case, finding feces in raw sewage and battery acids were irritants and contaminants. These cases have all rejected that exact same argument.
But aren't
which-
those typically chemicals or feces, something like that, as opposed to, for lack of a better word, whatever leaked out of this gentleman's body? I mean, it just doesn't seem like it fits into those examples. What about the rule that we would construe exclusions narrowly and coverage broadly? How does that impact our analysis in this case?
I don't think it does because, again, the Supreme Court found it unambiguous. all of the arguments that opposing counsel has raised about the different methods that courts have used to interpret policies where they are ambiguous. And I don't think that there's anything about this pollution exclusion that clearly and unambiguously would accept bodily fluids from it. And given the broad language in the Denny case, which specifically says we're not limiting our interpretation of this clause to specific things having to do with environmental pollutants. I think that the courts that since then have had no problem finding that even though exclusions are generally construed narrowly, that the pollution exclusion is nevertheless broadly worded enough to cover bodily fluids and other kinds of contaminants.
Yeah, so I was interested in your brief and your reliance on statutory definitions, from unrelated statutes. The reason being because, our rules of construction is you typically apply the plain and ordinary meaning of language unless there's a statutory definition, right? And one of the reasons you put in a statutory definition is precisely to give a term meaning in the context of a statute that may be different from its plain and ordinary meaning. In other words, if a statute says for purposes of the statute, blue means green, red means yellow, black means white, then we would construe it that way, despite the fact that nobody would normally construe it that way. The legislature can give us different definitions. So to me, the fact that an unrelated, unless it says, hey, this is for purposes of interpreting Florida insurance contract or something, the fact that you have a statutory definition, an unrelated statute, I'm not seeing why we should take that as evidence of the plain and ordinary meaning of a term as used in a contract, because the whole reason that you put into it in a statutory definition may be to deviate from the plain and ordinary meaning, which is what we have to use in this case.
No, I understand that, but if you read the Denny case and the Fogg case, both of which in the Supreme Court actually referred to a pollution statute having nothing to do with insurance coverage in reaching their decision as to the clear and unambiguous meaning of that term. And certainly this biomedical waste statute could be used by the court, by this court, and should have been used by the trial court as evidence that, yes, we're not talking about demand on the street. We're not talking about reasonable expectations. What we're talking about is the term waste and whether or not bodily fluids can be deemed waste. And under the biomedical waste statute, yes, they can. The medical profession, the legislature has deemed that waste is anything with the threat of infection to humans, including human tissue and bodily parts, blood and bodily fluids.
But
Why?
it's not clear, that statute was designed, if I go to the hospital and they take out my appendix, they can't just put it in the waste basket next to the operating table. They have to dispose of it properly. That's the clear scope of that statute. Isn't it?
Correct. And they have to dispose of it properly because it can be an irritant or contaminant to the general public. And again, we go back to what are we here for? We're here about the damages to property that was allegedly having to be cleaned up by a remediation team.
So how long is your request in the Florida Supreme Court been pending?
Not very long. I believe Mr. Nation just filed his answer brief on jurisdiction this week. And of course, nothing's going to be done in the next 6 weeks at least. So.
You're obviously well into your bubble time. You got a minute and a half left. You can use it or say that.
Your Honor, I'll say it.
Pelly?
Good morning. So I started to prepare yesterday and I pulled out the summary judgment order. And I read the last two paragraphs. And it dawned on me, Judge Mize, there has been no summary judgment order. I mean, exactly what you said. I looked at it. But hold on a minute. This is an issue of fact for the jury to determine And it was, we weren't involved at the trial level, and they stepped, thereby establishing the facts in favor of the prevailing party. I don't know how it's appealable, just like you've said. There is no summary judgment order on this issue. Judge Gentili simply said it's an issue that's going to be resolved by the jury.
Can their interpretation of the order be that unreasonable and you accepted it for purposes of your briefing?
I missed it until I pulled out the order yesterday, and I'm sure it's never happened to anybody else, but I start preparing for oral argument, and I go, hold, and I literally pulled it out and go, hold on a minute. And there's no summary judgment.
Well, wasn't it clearly the intent of the parties here to say that the court found that the pollution exclusion doesn't apply and the bacteria coverage does provide coverage? And didn't the parties move forward essentially with that understanding and entering into the stipulation?
I don't think they did with, certainly they did not with regard to the pollution exclusion. In fact, their brief on page 4 says they're not challenging the fact that there was insufficient evidence of the nature of the remains definitively established that they constituted a pollutant. They said that in their brief. They're not challenging that part of it. We charge as error granting summary judgment for Taylor.
Yeah.
And so what's the error?
Is there any statement in the order where the court says, I find the pollution exclusion will never apply?
No. No, he's just saying based at this time with the facts present at this time. And so what is the posture of this
But
case?
do they even find, does the court even find that based on the facts presented at this time, it doesn't apply? Or does the court just find the defendant has not demonstrated that it applies?
Correct, has not conclusively demonstrated. So he's just denying summary judgment. Believe me, I went through all of this yesterday, looking at, and I go, okay, and they're not challenging that finding. So what is the error? How can this court say Judge Gentili committed error and this is what it is? When the next finding is the uncontested evidence at this time, and you've read it, is, look, it's bacteria. But then you have a trial and they can bring in an expert and say, no, it's not bacteria, or it's only this little bit of it, and try to differentiate the causation because there's no anti-concurring cause language, and say, yeah, it's a $32,000 bill, but only $100 was for bacteria, or it never hit the floor. It's a factual issue at that time, but they still, and I agree. I think maybe what they were trying to do is just get the issues up, but procedurally, they didn't do it. Because there's no way how can the court say Judge Gentili committed error here? That order, there's nothing wrong with that order. And so the stipulation by trial counsel at the trial level doesn't change that. Having said that, as long as there's blood involved, it's going to conflict with the world. And if you read the world decision, it is a very well-written decision, and it makes sense. If you look at the man on the street, nobody's going to think that a body, most people die at their houses, that body then is going to be considered pollution and irritant. If we look at the definition, and it must be interpreted here.
Well,
It has to be.
it wasn't the body that caused the problems. I mean, if he passed away in his house, as many people do, and had been found promptly, picking him up and taking him away wasn't the problem. Wasn't the problem that he sort of leaked out, and it was the fluids and that sort of thing?
That is, and it was over the course of 10 days, I think.
Of course, so counsel, pretend it had been a year.
Okay.
Okay, guy lives alone, nobody finds him. And so as a result, literally the bile starts changing composition, right? The blood starts releasing methane, right? Bodily, the organs start decomposing and having physical chemical interactions with each other.
I
Doesn't that
think
get it closer to the definition of pollutant?
and you raise a great point, yes, and you get closer, and that's what Denny meant. If you look at it as here's the pollution exclusion, I draw a circle, that's the exclusion. And what the Supreme Court said in Denny and Fogg is, hey, with ammonia and pesticides, you're dead on. You are fitting comfortably within that exclusion. But as you get further and further and further away, At a point, you are outside the exclusion, no question about it. There was a point also on the edge where it's ambiguous. This is outside that exclusion. This does not fit within that exclusion. And even if it was close, it would be ambiguous. But I don't think it gets them there because there's anti-concurring clause language. So if any of it, I mean, there is no anti-concurring clause language. So if any of the loss is caused by something outside the exclusion, flood, according to world, the whole thing's covered. Unless they can get in and parse it out. They had that opportunity given Judge Gensler's order. They didn't take it. And here we are.
What you're saying is that fact that there's a spectrum and it's ambiguous might speak to how the judge ultimately resolved the case. In other words, letting it go to trial.
Well, he didn't say that, but certainly he's saying Florida Farm Bureau didn't present evidence that conclusively established the exclusion applies. The plaintiff presented some countervailing evidence, not only on pollution exclusion, but with regard to bacteria. Let the jury sort it out. Judge Bagg can come in, or Dr. Bagg can come in and testify. I get what the intent was. They didn't do it. And we can't undo what they did do in this case. And it is a final point. It is pollutants means any solid, liquid, gaseous, or thermal irritant. None of that, thermal irritant or contaminant, including, and then it gives its list, smoke, vapor, soot, fumes, acids, alkalis, chemicals, and waste. And none of those fit. And the final point is, it's unrebutted. If that is a final summary judgment in favor of Mr. Taylor's estate, there's no evidence to say it's not bacteria. And if bacteria is part of the loss, the whole thing's covered.
So you think summary judgment was granted, but if it was proper?
No, I can't tell you. No, summary judgment was not granted. I can't say that. It wasn't. As I read this yesterday, I'm like, this, I don't know how it got here, but here we are. And
Well, if we conclude that summary judgment wasn't entered, then, what are we to do with this?
you got a PCA, I think, if you want to write an opinion on it, that's fine, but there's a final judgment. Whatever the facts are that established that final judgment, we don't know. Nobody knows.
In other words, when you stipulate to entry of judgment, you cease to preserve issues for appeal.
Sometimes, some factual issues.
If you stipulate without reserving any specific issues, you waive them.
Right, and I agree that in certain circumstances, it's certainly more expeditious for the parties to stipulate. And for example, if this said, or the estate went back and said, you know what, we got to do this right. Let me just go get summary judgment on this issue. And if Judge Gentile then said, this bacteria occurred, no factual dispute about that. There are no, or they could stick to the facts, and it is covered as a matter of law. They stick to that judgment or step after that, then we're here on the merits. Unless they do that, how do you get to the merits? Because he didn't do that. The estate needed to go back and say, hey, I'm going to do a or summary judgment on this issue so that we can have this teed up properly. So, I'm done. All right, thank you.
I want to first refer to the order on the motions for summary judgment and specifically the wording, even if bacteria would otherwise have been.
What page of the order are you on? Counsel?
Excuse me?
What page of the order are you on?
Page 479 of the record, page 8 of the order. Additionally, even if bacteria would have otherwise been excluded under the pollution exclusion, here the additional coverage endorsement would supersede the exclusion. Based on the foregoing, the additional coverage for bacteria provides coverage for damages claimed by plaintiff. That is not a question of fact. That is a finding as a matter of law without regard to the evidence.
But counsel, it's a finding in an order denying summary judgment. Can you appeal orders denying summary judgment?
No, you cannot. You cannot. But nevertheless, this is what the court found with respect to whether or not there was coverage. And since the court made that finding as a matter of law, not as a matter of fact, then the only issue remaining was damages. And therefore, that was the reason why the party
Well, but did
stipulated.
the court say you couldn't argue that again at trial?
Well, it was an issue of coverage, so we wouldn't have,
Did the court say summary judgment granted, you don't get a trial on this?
no, the court did not say that.
All right, your time has expired, counsel.
Thank you.
Thanks, everyone.
Thank you.
I think we have some law clerks in the audience. Ms. Catalano, do you want to introduce your law clerks? Come on up, please, come on.
You know, two law clerks and